Hey everybody. This is the first time we're using this platform. I'm going to ask my tech person Xander Toulouse. Xander, are we live and is it time to commence this?
You're live. You're ready to go.
Okay. Um, hey everybody, it's Stephen Donziger here with the Independent Trial Monitoring Committee of the Greenpeace trial. We're really fortunate tonight to have some extremely distinguished attorneys and advocates with us on this call, members of the Trial Monitoring Committee. Marty Garbus, who's the legendary civil rights lawyer from the United States, my good friend. Jeanne Mirer, who is the president of the International Association of Democratic Lawyers and one of the stalwart human rights defenders on the globe. I love
You need
Jeanne.
my phone? You need my
What?
phone?
That's my phone.
That's your
Oh,
phone.
sorry. You guys see if you
Yeah.
can mute Marty while we talk. Yeah, there we go. Okay, and Jeannie is someone we're really fortunate to have on this group and really appreciate you being here, Jeannie. And then we have Natali Segovia, who's the executive director of the Water Protector Legal Collective. Natali is a good friend. She represented me in my litigation against Chevron and in my proceeding to try to get a pardon from President Biden. She's an incredible lawyer and has been involved in this case against Greenpeace that we're going to be talking about for a number of years in one capacity or another, beginning in 2016 with her stalwart defense of many people charged with trespassing and other you know property crimes, et cetera, in the protest against the Dakota Access Pipeline. And we also have Ayisha Siddiqa. Ayisha, she can, by the way, all these people can talk more about themselves when they talk. Ayisha is one of the young climate leaders in the world and in our country who I deeply, deeply respect. We've done some work together over the last couple of years right now. She's done a lot of work with the United Nations. She was named Time Magazine Woman of the Year a couple of years ago. And she right now is a first-year student at UCLA Law School. That sort of doesn't quite capture her expertise or the breadth of her experience because she's traveled all over the world dealing with climate issues. But we're really fortunate to have Ayisha on this call and on the trial monitoring committee. Um, just to check in with Xander. Xander, is everything okay so far?
You're all good.
Okay. So I'm gonna talk for a couple of minutes on what I think this case means. Then I'm going to turn it over to our other speakers to sort of give their commentary. If people want to ask questions, you can ask them through the chat. And we're just going to sort of present to you what we've observed with our own eyes and heard with our own ears was as members of our team have been sitting in the trial court in Morton County, North Dakota, watching this trial against Greenpeace. Now, sort of the big picture about this trial is it probably represents one of the most audacious and extensive harassment lawsuits against any large environmental group in our nation's history. As many of you know, Greenpeace was founded in the 1970s. They captured the imagination of the world by going out in Zodiac rafts in the North Pacific to block giant Russian industrial whaling ships from killing whales. They fought nuclear testing around the world and fought fossil fuel development. And they've done a number of creative actions in countries all over the place. They have chapters in 40 different countries. They played a very, very minor role in the Standing Rock protests against the Dakota Access Pipeline back in 2016. And a couple of years after those protests ended, the CEO of the pipeline company, it's called Energy Transfer, his name is Kelsey Warren. He's a billionaire and a major Trump campaign donor. He decided to go after Greenpeace, I think, as retaliation for all of the protests, which were indigenous led mostly by the Standing Rock Sioux, which has their unceded lands all around the pipeline. The pipeline traverses their lands. In any event, it was always bizarre to us to some degree that Energy Transfer decided to target Greenpeace, given that they only had 6 people in protests that where 100,000 people attended. This is what we call a SLAPP lawsuit. A SLAPP lawsuit is, SLAPP stands for Strategic Lawsuit Against Public Participation. They're designed by the party bringing it, usually or often a private oil company or powerful corporation. They're designed to silence their adversaries by imposing on them what could be years and years of expensive litigation. Whether or not you win the litigation is almost beside the point. The idea is to use the litigation as a weapon to crush your opponent and get them to stop advocating for their position. And that's why we think they went after Greenpeace as opposed to other entities that were more involved in the pipeline protests. It's really, as we see it, an attack on the climate movement as a whole. It's an attack on indigenous rights because the Standing Rock Sioux really were extremely involved in the protests. But they're going after sort of the side group as a way to get at the Standing Rock Sioux. Natali's going to talk a little bit more about that. The trial started on February 24th. It's going to end on Monday. I've been there, Marty's been there, Natali's been there, and we have people there now on the ground. We will be there throughout the trial, and at the end of the trial, we're going to write a report about whether this trial adheres to minimal standards of due process, fair trial rights, according to the U.S. Constitution, state constitution, and international law instruments. So we're going to be writing a major report. I will say we have a website, trialmonitors.org. We have not been shy about the fact that we have major concerns about what we've been watching. This trial does not seem fair as regards Greenpeace, and you can read about some of those concerns on our website, trialmonitors.org. And today our speakers are going to sort of be talking about some of the concerns as well and giving their impressions. So I'm going to start by turning it over to Marty Garbus for the first comment. For those of you who do not know Marty, he's been practicing, he's been a litigator for decades. His clients have included Nelson Mandela, Václav Havel, Daniel Ellsberg, Cesar Chavez. I was fortunate enough to get his pro bono representation during Chevron's criminal contempt prosecution of me back in 2021. So I am always feel such tremendous gratitude to Marty, and he has a perspective few others have in the world on this type of case. And I want to turn over to Marty, who has been in court in North Dakota, to provide the first comment on what you think of this SLAPP harassment case by Energy Transfer against Greenpeace.
Steve, that was a wonderful summary of where we are. You're really very good at that. I think there are two separate things going on. And one of them was going on today outside of this trial, and another is going on in the trial. Outside of the trial, it's very clear that the Trump group is trying to get a reversal of Times Against Sullivan, the great case that would protect Greenpeace in this particular case. And they're also trying, with respect to Greenpeace, to get the new standard into effect for the first time against an indigenous organization. So many of the Trump suits that are filed throughout the country are dealing with the exact same problems that we're dealing with in Greenpeace. The judges have said that they're prepared to overrule Times Against Sullivan, which gives Greenpeace all the protection it needs. So that's a critical issue for how this judge interprets Times Against Sullivan. My suspicion is he'll interpret it badly, which is to say that he will not set aside a jury verdict. I mean, ultimately, a jury trial such as this comes down to the moment when the juror stands up afterwards and says, this is our view. We already know that 7 of the 9 jurors work for or are involved with the oil and gas companies. We know that 80% of North Dakota is tied into the oil and gas companies. The idea of having this case before this judge in this county or even in this state is horrific. I was involved in the Wounded Knee suits back in the 1970s. And there, when the everything happened in South Dakota, But when certain trials came about, they were taken out of the state. They were federal cases. You could do that. It's a little harder to do it with this state case. But no one has ever suggested that a jury like this could possibly, in other words, when you have a number of women in the jury, young women, young families, they're going to come out to dinner and they're going to see their friends. And some people are going to lose jobs who work for the oil and gas. They may relate it to this or they may not be. But they certainly can't go to dinners and be part of a social life here if they're known as the person who basically did not go along with the plaintiffs, in this case, the energy company. It would be far too difficult for them. We went over all these same issues in the South in the 60s and then at Wounded Knee in the 70s with Leonard Peltier, with Peter Matheson, with his book In the Spirit of Crazy Horse. And this just follows in that line, except in those cases, we never got this far. We got them all thrown out beforehand. And I would not be optimistic about this judge throwing out. For this judge to throw it out would really be to self-criticize and say, I made a mistake. The jury came back with a verdict, but I'm going to go with the jury verdict. I don't think he's going to go with the jury verdict that comes out against Greenpeace. And I think the jury certainly knows that. So I think, I'll sum up. We'll see what happens Monday. It's an extraordinary day in American legal history, both for Indigenous rights and the First Amendment and for the democracy. Thank you.
Thanks, Marty. That was great. I just want to say a little background on what Marty's saying about the jury not being fair. Greenpeace submitted a study from the National Jury Project that was done prior to trial, where they surveyed a lot of people in this small county, Morton County, of 33,000 people, and 97% of the residents of the county openly admitted that they could not be fair as a juror in this trial. And that, by the way, is a huge warning sign for a judge to change the venue to a locale where people are not so personally involved in the issues that are being litigated. That is, this is the county where the protests, or a good portion of the protests, took place. And many of these protests block roads. They were generally very, very peaceful, but they did cause inconveniences to people, particularly people who work in the fossil fuel industry. The county voted 75% for Donald Trump. It's not the kind of county where an entity like Greenpeace can ever expect to get fair trial. That's been our impression, and a lot of it boils down to the jury. I'm going to now send it to Natali Segovia, the executive director of the Water Protector Legal Collective. For those who are just getting in, I just want to repeat that Natali has literally been involved in this litigation since its inception back in 2019, when Energy Transfer first sued Greenpeace. If you can believe it, this has been going on years and years and years. Natali also was at Standing Rock during the height of the protests, organizing legal representation for people arrested by police for their protesting activities. So she has a broad perspective on this. Natali, it's a pleasure to have you here. Thank you so much. I'm turning it over to you now.
Thanks, Stephen, and thanks, Marty, for that introduction also on the case. If I can zoom out for a moment, this case actually started in 2017. So it started in 2017 in federal court, right? And the case at the time was really about bringing together, I mean, it was using RICO, right? Racketeering laws that have been in place since the 1950s, 1960s to prosecute the Chicago Mafia. Right. So we're talking about a set of laws on a federal level that were specifically trying to target criminal enterprises. So if you go back and read the original complaint filed in 2017, they call Greenpeace and all the NGOs, right, that showed up in solidarity with Indigenous peoples, because the No DAPL movement was and continues to be an Indigenous-led movement. What we saw was Energy Transfer via their law firm, of choice at the time, and since then, Gibson Dunn, saying, we're going to call this the Enterprise. So they called it the Enterprise. And if you read through the complaint, it reads like a work of fiction, right? This really great work of fiction where NGOs are somehow, making it possible for, or impossible rather, for pipeline companies to be able to build what they deem critical infrastructure. So fast forward to 2019, the federal judge dismisses the case and says there's no there here, right? This case is gonna get dismissed, and it gets repackaged and refiled in state court in 2019. And this is the case that we're still dealing with today. So it's been nearly 10 years since Standing Rock. And at the crux of the issue at Standing Rock, right, the reason why tens of thousands and, they estimate over 100,000 people pass through Standing Rock. But at its peak, between 10,000 and 15,000 people, they went and they flocked because there was a call to protect the water. And if you have the opportunity to go to Standing Rock, one of the things that you will see is that throughout, and part of its geography, it derives water from the Missouri River, and most importantly, which is a source of water for 18 million people, and most importantly from Lake Oahe, which is the primary source of water for the Standing Rock Sioux Tribe, the Cheyenne River Sioux Tribe. And Lake Oahe is right in the middle of the reservation. But what you see, and technically on what they call federally managed lands, but it's unceded treaty lands, right? And so what you see, and the kind of the way that the pipeline is built, is you have Lake Oahe here, and the pipeline was dug underneath the lake bed. And so you can understand, and any person can really understand, why this could be critically important to anybody living in the community. The very source of water, right? The ability to have drinking water, running water, access to water, which is essential to existence. It's not just a motto. It's not a catchphrase. Water is life is not a catchphrase. It's a truth, right? So what people were there to do was to protect the water, to protect and honor treaty rights. And at its core, this case is still about the water, right? Energy Transfer has tried to make it about everything. And mainstream media has really addressed this case as an attack on free speech, an attack on dissent, an attack on, it's big oil versus big green. And it is all of those things, right? It definitely is. And it's that and. It's that and an attack on Indigenous peoples. It's that and an attack on the water itself. It's that and an attack on the right of Indigenous peoples to stand to protect the water and to protect it for future generations. And guess what? It wasn't just an act of protection for Indigenous peoples. It was an act of protection for the water that's the source of water for North Dakotans and South Dakotans and all of the people that derive water from the Missouri watershed. So, in the context of that, what we are seeing and the way I see this case, beyond an attack on dissent, an attack on free speech, and an attack on the largest environmental nonprofit organization in the world, Greenpeace and its history, it's also a proxy war against Indigenous peoples. It's a proxy war against tribal sovereignty and self-determination. The questions that are at issue at the heart of this case are essentially questions that Greenpeace is not in a good position to answer, right? It is not in a good position to answer what are or are not, or what do or do not constitute tribal lands, or what do or do not constitute treaty lands, right? Beyond what is historically acceptable and historically known to the public. That requires experts, right? Tribal experts, tribal cultural experts. So there's just so much in this case. And then, last week we heard Vice President of Energy Transfer, Joey Mahmoud, on the stand, and he got up there and said everything that the tribe had talked about, the destruction of sacred sites and burial sites, was, for lack of a better term, fake news. So you're seeing this constant erasure and narrative of erasure coming out of the witnesses that Energy Transfer is putting on the stand, coming out of Energy Transfer's legal as a part of its legal strategy. It's a fundamental part of its legal strategy, and it's not by accident, right? It's not an accident that it's Gibson Dunn that was also representing Chevron in its attack on you, Stephen, right, in the RICO case. It's not an accident that Gibson Dunn took pro bono the Brackeen case, which all the way to the Supreme Court, which was an anti-Indian Children Welfare Act case, right? So it's been an attack on tribal sovereignty, and for anybody that is stepping in to protect the environment and protect the rights of Indigenous peoples and are adjacent to that. So that's a pattern of conduct that we see here.
Thank you, Natali.
But
Yeah. We'll come back around. I just want to say though, that the original federal case that Energy Transfer filed against Greenpeace back in 2017, I was wrong on the year, used the civil RICO statute, which is again a statute passed by Congress to go after organized crime. It's been utilized by corporations against activists with increasing and alarming frequency. And Chevron used the same statute to sue me and my colleagues in Ecuador after we won a landmark pollution judgment against that country down in Ecuador, which has led to a whole years and years of me fighting Chevron in a series of legal actions that eventually led to almost 3 years of detention. But I just want to mention that because there's a playbook involved in this case. I believe it's a fossil fuel industry playbook. And the same law firm that Chevron used to use it against me, Energy Transfer is using to go against Greenpeace. That's not an accident. This is a law firm that is selling this playbook to corporate clients to make money for itself at the expense of the climate justice movement, groups like Greenpeace, advocates like myself, and I believe the First Amendment right to protest, because they essentially have a legal practice dedicated to attacking the First Amendment on behalf of their corporate clients, which is, I see, sort of central to what's going on against Greenpeace right now. So that's a little more context. I'm going to turn it now over to Jeanne Mirer, who is a person I deeply respect and admire for so many reasons. Again, she's the president of the International Association of Democratic Lawyers, one of the largest legal organizations in the world. They do great human rights work all over the place, and they really stand up for people and groups who are being attacked in this way. They stood up for me when Chevron was targeting me, and Jeanne is just, I can't say enough about her in terms of her career of great legal work. So Jeanne, I'm just curious, what do you think of this case based on your vast experience seeing all sorts of crazy stuff that corporations do in court?
Well, I think you're right, Stephen, that this is a playbook that Gibson Dunn has, or the corporate movement has, because, you know, in your case, we found the document that said where the playbook from Chevron was demonize Donziger. It wasn't anything that had to do with the, you know, the merits of the case. It had to do with if we distract and demonize somebody who is standing up for the indigenous people of Ecuador and, you know, dealing with the pollution that they suffered, they can take the focus away from their misdeeds. And that's exactly what's going on in this case. The playbook is to demonize Greenpeace, and by that indirectly the environmental movement and all indigenous peoples who have been the leading force for protection of the environment. You know, the indigenous movement is I think the largest and the most outspoken in terms of understanding the relationship of people to the earth and preserving the environment and our relationship to it, and not doing what we're doing to it now, which is, you know, creating unlivable conditions for the rest of the world. So I've always been, you know, I was actually years ago involved in Wounded Knee and the Attica struggles with the Lawyers Guild, which is the organization that is one of the major affiliates in the International Association of Lawyers, but concern about this. Going back to what Marty said, and the reason why this is now at state court is what on the civil RICO, they had certain state claims that they were claiming were torts and part of this enterprise. And the court said, well, we're not going to hear the federal case, but the torts involved defamation and, and tortious interference and things of that sort. And that's where the question of Times v. Sullivan comes up, because I don't know if people know the history of Times v. Sullivan, but the case against the Times was brought by a white segregationist in the South who claimed that some reporting about how Black people were treated in the particular town where I think he was an official. He brought claims against them and said they made mistakes, and therefore, it was libelous. And the court said, wait a second, to preserve freedom of the press, to preserve, our ability to make statements that we have a good faith belief are true, because a defense to defamation is truth. That you can't hold a public official can't hold the newspaper liable for defamation if they had a good faith belief that what they said was true, or they didn't have a reckless disregard to the truth or the falsity of what they said. And that's a very important standard to protect people making statements. Now, the other aspect of this is that if people say, this is my opinion, and the opinion isn't based on facts they know to be false, then it's protected First Amendment opinion. Your opinion is not defamatory. It's if it's a good faith opinion based on what you know to be true or believe to be true. So the reason why this is so important is that from what I could see in the courtroom and from everything that's been reported, and I've been meeting with the monitors every night, is nobody is really arguing the actual standard of what you have to show that somebody actually defamed another person. It's a they're saying, well, don't you want to make sure that everything you say is absolutely correct? Well, of course you do, but that's not the standard for defamation. If in fact what you said isn't completely correct, but it was based on a good faith belief that it was. Anyway, these are some of the issues that I think are critical in the legal sphere. I'm very concerned about everything I've heard about the way in which this case is proceeded. Obviously we have daily reports from those people on the ground, but there has not been from the ability to have this case have a public trial. This case is not public. It's been shut down at the request of, and the courts have refused to open it up so the public could hear it. And it's and the rulings from the court, I have the standards for impartiality, the standards both international, national, constitutional, the standards for impartiality and the diligence of the court in running a trial. I have many concerns about that, and these will be in our papers. So that's what I have to say.
Thank you so much, Jeannie. I just want to say before we go to Ayisha, if people have questions, excuse me, you can stick them in the chat and we'll post them on the screen and, try to deal with them. I also want to say that we have been joined by Scott Badenoch, who's been coordinating this operation with great skill. Scott, hello. He's with law students from I think Columbia, we've been so blessed. We've had literally 16 like really smart law students join our team in a support role, and many of them have gone to North Dakota and are monitoring the trial, taking extensive notes. One of the super odd things about this very high profile trial, Jeannie said that it was secret. I mean, technically it's not secret. You can walk in the courtroom and watch it, but what's bizarre about it is there's no court reporter, there's no daily transcript being made. Most high profile cases in North Dakota are live streamed to the public. They wouldn't live stream this case at the request of Energy Transfer. Then a bunch of media groups asked for the North Dakota court to order the live stream. They were unable to get the live stream. So if we had the live stream, everybody around the world could watch this trial. But I think, in my personal opinion, I think that Energy Transfer and the judge, to some extent, they don't want people to see this because they're not proud of what they're doing. And I think after Ayisha speaks, we can hear maybe directly from Scott and some of the monitors who've been in court this week. Excuse me. At first, I'm so proud to have Ayisha Siddiqa on our monitoring team. Ayisha has a tremendous amount of experience as a climate justice advocate. She's worked very closely with the United Nations on a number of interesting projects. We've spoken on panels together. Obviously, she's a lot younger than most of the rest of us on this committee. I'm really proud to say that she is now a first-year law student at UCLA and has been helping us sort of look at this. And I want to turn it over to her to get some perspective. Obviously, you should say whatever you want, but I'm really interested to hear how this looks to you, this whole model of going after environmental groups, to a young person starting out in her legal career. I think you might be muted.
I was indeed muted.
Okay.
Thank you so much,
Yeah.
Stephen, for the introduction, for including me in this phenomenal monitoring team. My background, just a little bit. I'm not just only a climate advocate. I come from a small indigenous community in Pakistan. And so the tactics used by big corporations, whether they be of the nature that Energy Transfer is doing, or the small, slow, steady pollution that has killed so many people across the world are not surprising. What is interesting to witness at this point, because I was in high school under the last Trump administration and I'm in law school now in his second term, is the degradation of protest in our country across the board. It's not just this case, and I think we as a monitoring team also have a responsibility to tie what is happening at the global scale and at the national scale together. So it's the protesters at Columbia University that are also being targeted. It is the young people that have been taking on governments and leading small federal suits that are also being targeted. And I think Jeannie had spoken about the First Amendment rights being in question. I think we're seeing a kind of McCarthyism that we saw previously after World War II, where anyone with any sort of a dissenting opinion was labeled, for a lack of a better word, a threat to society. And I think just witnessing this happen, it's even more important for us to be principled in what we consider to be just and right. And I think it's so interesting that Gibson and Dunn have labeled everything that the communities around North Dakota are saying as fake news. We are seeing just a collective memory loss, and this has happened in many regimes across history. It happened in the Pinochet regime. It's happened in Latin America throughout. Just forgetting, and we cannot afford to forget what has happened because of the climate crisis. But more importantly, Stephen, I think at some point you mentioned future generations. The consequence of this case going the way that it is going is it's going to impact and put us 5-10 years behind. All that work that my colleagues and I did at high school, protesting every Friday, trying our hardest. I mean, to have just a federal government that took the climate crisis seriously is going to set us back X amount of years. And not just that, but the kind of dissuasion that is happening across our generation, my generation as at least, it's an early compliance. We're seeing it from institutions across. I'm at UCLA. I mean, my university is known across the world to be one where critical race, DEI, and so many other initiatives start, and also have emphasized this for environmental justice. And the thing that I'm scared of, especially as a young person, is early compliance from institutions across the board, from institutions after they watch this Greenpeace case go down, from people all over, because they're afraid of the threat of this administration. And if that happens, what we will see is a kind of decrease in all of this fervor and all of this uplifting in all of this protest that we spent years to build. And it's rather concerning. From a young person's perspective, from a perspective of someone who was at the dawn of the climate justice movement among young people in 2019 to now, even the UN has, been attacked in so many ways because of the Trump administration. I think we need a response to this kind of fascist regime, like we did past in history, where we collectively decide that we're going to take radical action, where we collectively back up certain individuals, where we collectively create support systems. Otherwise, they're going to rip us one by one.
Wow, thank you, Ayisha. I'll say along that point, these SLAPP cases, the one against me, there's one now in Cop City against 61 people, a RICO case in Cop City, people who protested the Cop City complex down in Georgia, the Greenpeace case. These to me are all designed to sort of create a major energy shock force that really demoralizes people such that they just withdraw from political life or civic life, go into just do, how many people have you heard say, let's just do our own thing now, this is impossible. Okay. But that's exactly what the forces who have taken over our government want us to do, which is to lay down. And I think you mentioned Colombia. We all know about this recent case with Mahmoud Khalil, who was really abducted by ICE from his home without a warrant last Saturday night and is still detained for clearly a politically motivated attempt at deportation, and by the U.S. government, by the Trump administration. All of these cases, to me, are SLAPP cases. That is, they are designed to violate people's rights to speak out, to protest, to advocate, protected by the First Amendment to the U.S. Constitution. Marty said at the beginning, the earlier cases he worked on that reminded him of the Greenpeace case never got this far. Think about that. Those cases were dismissed before trial. Marty, that's correct, right? Those cases you were talking about? Yeah. And why did this case get to trial? Why did my case get to trial when it was so clearly a baseless case that had no real basis in the law? And I think we're seeing a more politicized judiciary that is judges, because of various, political reasons. By the way, this is well documented in a book called The Scheme by Sheldon Whitehouse. The Federalist Society and the Koch brothers and those forces in our society have pretty much been able to exercise significant control over or influence over too many federal judges and state court judges. And you're seeing judges more and more willing to allow these illegitimate SLAPP cases to happen. Because again, no matter the result, I do believe, by the way, I don't mean to be negative, I'm a very optimistic person. Greenpeace is very likely to lose this case, not because it did anything wrong, but because the trial was fundamentally unfair. It's a jam job. It's a political trial, in our opinion, or at least in my opinion. I don't want to speak for the group. But, we have to recognize that Ayisha talked about not forgetting. Like, let's remember these cases and understand, open up and understand that you can connect the dots here and see a pattern, a playbook. And, you know, for the young people like Ayisha and the younger climate people, you know, dealing with these SLAPP cases, reversing them, creating laws to block them from happening is really critical to protect the freedom to protest and to advocate for a sustainable planet. And it's not surprising, of course, that the fossil fuel industry is attacking the right to protest because it's been so effective. I mean, the climate movement has grown so strong in recent years. And now we see this weaponization of the law to stop people from protesting, lock people up, or sue the hell out of them because Greenpeace faces hundreds of millions of dollars of potential damages in this bogus, what we believe is a bogus, baseless, you know, attack on the First Amendment. So these are very serious issues. And I think one of the purposes of this live stream tonight is to start raising some of these bigger issues so people, you know, can focus on them a little bit more, especially with all the confusion and chaos that's, you know, sort of being imposed on our country now by the new government. We have a couple of questions, but first I want to just allow Scott Badenoch, who's been probably in court just about more than anybody, who's running our trial monitoring operation. He's with students from Yale. Scott, do you have any thoughts about anything you've heard on this call or anything you want to add about what's going on the ground in the trial?
Well, where to start, I guess, is a better question. I would say the first thing I want to note is that the right issues, the real issues pertaining to this underlying story are not centered in this courtroom, and that there is institutional marginalization of the Native American communities who were the center of this entire effort and their issues. And I think it's important to note that marginalization, that historic marginalization, continues here in this courtroom. The second thing I'd add is we monitors have been the only public safety net for what's actually happening in this trial. There is no daily transcript. There's no recording allowed. There's no live stream. There's been no access short of us coming to the beautiful town of Bismarck and then driving to Mandan and enjoying the courthouse there physically every single day and taking reams of notes by hand as if we are monitoring a trial in 1980. The problem is that courtroom is a multi-million-dollar 21st century courtroom that has all the capacity to do these things that the public service typically does. Instead, we find ourselves doing it, and we are not a transcription service. So I find this very telling that the capacity, the big plasma TVs, cameras, the mics are all there. There's a sound guy who works all day, but yet they can't provide all these things for a civil tort trial. This is not a national security trial or terrorism. This is not child abuse. This is a defamation tort trial. There is no justification for the lack of transparency that we've seen at every level in this case. So I also want to just sort of start with that, noting my frustration. Monitors are not meant to be transcription services. We're meant to go there and see what's happening in court and then be able to check that with the transcript later that night to confirm what we saw actually happen. We have not been able to do that. So this feels very much like 2 generations ago trial monitoring efforts did.
So I have a question. Do you think the judge is deliberately trying to get in the way of the work of the monitoring committee when you say these things? I mean, do they not want scrutiny, I guess is my question.
I wouldn't say that they care much about the monitoring committee, but we did get a direct response from the court when we asked for any of those things, any of them. And their response was, our court does not have the resources to do so. Well, I've seen in the courtroom more than enough resources to do so. So why Judge Guillen felt it was necessary to fabricate his answer to why we can't access publicly the trial, I don't know what his intentions are. I can't pinpoint that. But I do know that every single step he's made has been against transparency. And that has been the absolute pattern here. Just in the 2 weeks that we've been here, now 2 weeks and whatever days. But it's been very, very obvious. So I also just want to note that today we saw Kelsey Warren, the CEO of Energy Transfer, provide deposition testimony where he was asked if he knows who Earth Justice is. And his response was, "Oh, yeah, they're scumbags." And then goes on to explain that they were the ones that must have given some major bribe to the Standing Rock Sioux tribe so that they wouldn't take his bribe. And he described literally going to David Archambault with...
Explain who that is. Explain who that is.
David Archambault was at the time the chairman or the leader of the tribe. And Kelsey Warren describes going to his home and offering him cash and saying, "What do you need? What do you want, David? What can I offer you to get this thing moving?" He admitted that in the deposition today. After calling Earth Justice scumbags, Earth Justice being the same nonprofit firm that stepped up to represent the Standing Rock Sioux tribe. So those are the scumbags. And he was more than willing to offer that on recorded deposition testimony. It showed his deep, palpable hatred for climate action and the lawyers, particularly, that represent those folks. So I think that was just really telling today. But also today was one of the few mentions that this case has had of the vicious police brutality that was widely reported, not a rumor, not some side thing. We heard from an expert today that literally dozens of publications, all of the ones that you can name, covered that fact, that police brutality was happening out there, that dogs were being let on innocent civilians peacefully protesting. We heard about that today. We heard about the dozens of cultural sites that were bulldozed by Energy Transfer. The minute they found out about them, they went out with a bulldozer and ripped them up. We heard about that today. It's devastating stuff. We heard...
Scott?
Yeah, please.
Do you, I just, first of all, thank you for that. That was excellent. By the way, most people don't think you need trial monitoring in the United States because our legal system is considered by many to be like superior to that kind of thing. But, Scott is someone who, when I was going through with Chevron, called to my attention that we should do trial monitoring. He's been involved in a lot of environmental justice work with the American Bar Association. And, what we're realizing is the monitoring, just the presence in the courtroom, their awareness that you're doing this, their awareness that you're going to do a report on their behavior, on any flaws, on their misconduct, really has a extremely positive impact in a whole host of ways, which again is one of the reasons we're doing this event tonight. We will do more. And I just want to also say that somebody asked about the appellate process. So I want people to know that closing arguments to this trial are on Monday of next week. There'll be jury instructions. The jury will probably get the case on Tuesday to deliberate and decide whether to find Greenpeace liable for hundreds of millions of dollars of damages. If Greenpeace loses, there's only one layer of appeal at the state level, which is directly to the Supreme Court of North Dakota. There's no other appellate court in North Dakota. And then from there, if necessary, on to the United States Supreme Court. So, this battle will not end at the end of the trial. It will keep going for months, if not years more. And we plan as a monitoring committee to take our work and our observations and our conclusions and publish them in a way that we think will help protect the right to protest, the First Amendment, due process of law, and hopefully Greenpeace. Obviously, they have their own legal team. We're independent of them. They have very able lawyers. They will do these appeals to the best of their ability. But the trial has been pretty hopeless in terms of their chances. I want to just introduce a very special guest has been pretty hopeless since another. I want to just yeah, another stalwart defender of human rights. Roger Waters, founder of Pink Floyd, and what can I say about you, Roger? Roger, just so you know, has supported quietly so many human rights causes around the world, including the people of Ecuador against Chevron. And Roger, we're honored to have you here. I would love to, I know you've been listening. I would love to hear what you have to say about this Greenpeace trial and anything else you want to add. Thank you for coming.
Well, what a bunch of arseholes, eh? That's what I have to say. This is worrying to me because I can hear my voice through my phone, but it's completely out of sync with what I'm seeing on my laptop.
Just so you know, we're
Yeah.
hearing you really well in this venue. I don't know, maybe you should, since you're in this, you should if you're in this through your computer, turn your phone off.
Turning my phone off now, sir.
Okay.
Hang on. How do
Oh, that was real smooth. I just did something to lose Roger Waters. Okay.
He was on his phone listening on his laptop. I'll get him right back.
Okay, thank you.
Stephen, can I just add something really quickly
Sure,
here about,
absolutely.
Scott mentioned today that in the courtroom today, there was testimony about things that have been widely reported in the mainstream media. And I think that's one of the things that we're, if you look at the way that the arguments have been made here, they're making the argument that Greenpeace engaged in advocacy, and that advocacy should result in civil liability. That includes compensatory damages of $300 million and punitive damages of up to $900 million. So we're talking about $1 billion lawsuit because Greenpeace did the kind of advocacy that most of these oil companies are doing behind.
Can anyone else hear Natali?
I can hear her.
They were doing the advocacy that the oil companies were doing behind closed doors and lobbying people in Washington, right? So the idea and that premise, and that's what's so dangerous about this case, right? It's not just an attack on dissent and all these things that we've been talking about, but it's also an attack on advocacy, right? That means that any of our organizations that are environmental organizations, environmental advocacy, Indigenous rights advocacy, all of this is at risk. Because what that means is that if you send a letter, and there is a letter that is at issue here, right? There's a letter that was signed on by 500 organizations. Greenpeace was one signatory, not even the author of the letter. And they've been using this to say, well, because of that letter, 4 banking institutions divested from this project, they should be liable for the millions of dollars worth of, damages as a result. This is what they're calling it. So, and then just on what Scott said, that the desecration of cultural sites, it goes beyond cultural resources, right? One of the elders and knowledge keepers at Standing Rock has referred to it as a crime scene. So I think we have to be really intentional too about the language that we use, because these are burial sites, right? This is where people's ancestors were and are still today.
Thank you, Natali, for that. And I just want to mention Roger's back. We're going to turn to him in a second. I also want to say that Paz y Miño has joined us. Paul is the deputy director of Amazon Watch, the frontline environmental group that has fought so many incredible battles over the years to protect Indigenous peoples. And we're honored to have Paul on our trial monitoring committee. Paul, but unfortunately, Roger Waters was here before you, so we're gonna let him talk first. We'll come to you in a little
Hey,
bit.
Paul. Hey, brother. How are you doing, Paul?
These two guys met outside a court in Toronto when we were up there trying to enforce the Ecuador judgment against Chevron's assets, and they love each other. So I'm happy you guys are connecting.
Yeah, Paul and I are constantly meeting one another outside courthouses, trying to save your sorry ass. Usually.
I know, right?
But what can I say? Well, it's bloody good to see you both. I'm happy to see. What a bummer that this SLAPP suit is wasting our lives for us. And we all know why they're there, and we all know why they won't let anybody broadcast from the court, and why they're keeping it hush because they just want to cause as much damage. That's what SLAPP suits are for, as we all know. Listen, I tell you why. I was watching it, listening to you. It's all very interesting and whatever. But a few years ago, not a few years, a couple of years ago, I wrote a song about Standing Rock, which I haven't yet recorded, weirdly enough. But I thought I might share the lyrics with you if you want a slight diversion.
Wonderful.
Please,
I've got
please,
one.
absolutely.
Wonderful.
All right. This is dated the 5th of January 2021. So it's a while ago now. I'll just read it because it mentions our president, who was president then. In fact, he'd just become president when I actually started writing this song. And the first effing thing that he did was drive the DAPL pipeline straight through Standing Rock with an executive order, which I mention in this song. So without further ado, here it goes. Take me back to Dakota. Take this broken heart and turn back the clock, where the lone brave stands vigil over the sacred land of Standing Rock, where my friend Mateo, a good old Union boy, was trucking timber and sheetrock over the hill, across the Great Divide, building cabins to shelter the brothers and sisters, standing in line in front of some armed and dangerous rank and file. Scumbags, riffraff and such, fucking Pinkerton men. They're everywhere there's sacred land to blunder, everywhere there's a profit to be found, everywhere the man can make $2 on a life, everywhere the price is right. And back in DC, the cheapest of men, with his tiny little dick and his great big fat fountain pen, signs an executive order to hand over the sacred land to the Pinkerton men. And in the water cannon's freezing blast, it's getting fucking cold. I mean fucking cold, blowing 20 below. But my friend Mateo and the local braves cut their milk teeth at 20 below, and they have the love of their brothers to keep out the cold. So fuck you, Mr. President, and fuck your Pinkerton men. They're everywhere there's sacred land to plunder, everywhere there's a profit to be found, everywhere the man can make $2 on a life, everywhere the price is right. And it ain't just in North Dakota. They stole Bolivia in a coup, tried the same in Nicaragua and Venezuela too. They're in Tangier in Morocco, Lima in Peru, in Marrakesh and Mogador and Ouarzazate. Where are they? Ouarzazate on the edge of the fucking desert, due north of Timbuktu. And they're further south in Mali and the Republic of the Congo and other states where vultures wait for the old slave trade to merge seamlessly with the new. Anywhere there's a cash crop or a sweatshop, anywhere the people are ripe for the picking, don't look down, turn a blind eye. It's only another dead child, just another wage slave, anonymous, just another dead kid in a ditch with no fucking name. And who's this here, pissing on her grave? Yeah, the Pinkerton men are everywhere. Everywhere there's a profit to be found. Everywhere the man can make $2 on a life. Everywhere there's a free ride, everywhere there's a virgin bride, everywhere there's a fixed fight, everywhere there's a widow's mite. Everywhere the price is right. So I'm completely sure what that has to do with this meeting here today. Because this is the fight that we're fighting.
It has everything to do with the meeting.
Okay, Roger, that was unbelievable. And you got,
Yeah.
I love it if you would record that. Marty, what'd you think of that?
I thought it was wonderful. I thought Roger carried the very different levels of this case. In other words, it's extraordinarily complex, an extraordinary mobilization of forces against indigenous people, and extraordinarily amazing groups of forces that Trump has pulled together to end the democracy. I think what Roger just did is wonderful, as were all the other speakers, Jeannie, everybody. Thank you all.
Well,
Yeah.
Marty, thank you. Roger, what do you, well, look, obviously you've recorded a ton of songs. I'm just curious, and this is slightly divergent, but I'm really, I think people are going to want to know this. Like when you write lyrics to a song like that, do you have the musical composition in your head, or what do you? Why would you not record that? It's such an incredible. That's just beautiful, man. Thank you.
Yeah, well, yeah, most of them. I mean, the action that I'm talking about, Take Me Back to Dakota. I'm talking about Take Me Back to 2016,
Yeah.
Standing Rock, that we all remember. Well, my
Hmm.
friend Mateo he is a good old Union boy, and he does drive a truck, and he did drive there, and he did carry timber and sheetrock, and he carried it from Washington State up in the Northeast, and he did carry it, and he carried it across the Rockies to Dakota, and they did build shelters for the people who went there to stand with the indigenous people, the Lakota Sioux in North Dakota. And so that's what I wrote. But it was only at the beginning when I wrote it, it was only about those 2, 3 months, 4 months, 5 months through the winter of 2016, 17. It was crushed then when on January the 20th, when Trump had his first inauguration. After that, it was crushed. But it lives in our memories. And it's partly because of the bravery of the resistance of those people in that freezing water cannons, freezing blast that I talk about there. That is what keeps us going. This is why Paul and you and me fight for the rainforest people in Ecuador and in the Amazon basin for all the others that Paul represents as well. And so, yeah, we live in strange times. All of us are engaged in an existential battle for the soul of the human race, Stephen. I have probably said that to you before.
Yeah.
I say it to anybody I stop in the street or listen. I say, excuse me, madam, do you realize we're involved in an existential battle? No, I don't. But no, I don't. But I did stand up and sort of say something similar to the Security Council last week. And I've been invited to speak at the anniversary of Yalta at the end of this month. And somewhat reluctantly, I'm going to accept that invitation, and I'm going to go and say the same thing that I say everywhere. We have to make this decision, and the decision is this: do we believe in what we all signed up to on the 10th of December in 1948, which was the Universal Declaration of Human Rights in Paris? Either we believe in human rights or we don't. The judge that you're going and listening to, and obviously Gibson Dunn, or whatever they're called, and the rest of the arseholes who are bringing this SLAPP suit do not believe in human rights. They have absolutely no interest in human rights. They couldn't care less about the law.
I mean, I would say, sorry to interrupt, their business model is to make money by defending human rights violators. It's extraordinary.
Well, exactly. Yeah,
Yeah.
that's exactly correct. So, yeah, so these are extraordinary times. You know, when I spoke to the Security Council last week, I was talking about the veto that still exists, which was a sort of, it was a jolly handed out to the people who won the Second World War. Well, you can have a veto, you're on the winning side, and so can you. We'll give one to you, even though we don't like you, because you fought the Japanese, and that sort of thing. And but in consequence, the UN is a very worthy body, but it's toothless because of the veto. So we need to get rid of that. But there are other things that are hugely important. Is the Achilles heel, okay, in the administrations, because it's not just Donald Trump, they're all over the world now, these fascist administrations. Is their Achilles heel the fact that they've ripped off their mask and they are broadcasting to the world that they have no interest in international law or human rights or any of the stuff that we signed up to in Paris in 1948, and they are some of the ones who were standing there with their fingers crossed, hands behind backs, pretending that they care about the law and about human rights, when in fact they don't give a fig for it. All they care about is lining their pockets.
Yeah.
That's it. And power and personal power. So they love their Mar-a-Lagos and their private jets and their hundreds of billions of dollars in the bank. I'm talking about Zuckerberg and Bezos and Musk and all the other assholes who are supporting the chief arsehole Trump. I wonder how much longer they're going to think it's a good idea that I'm living in this. Actually, I'm not in the States at the moment. I'm very happy to say I'm somewhere.
Yeah.
But obviously what I'm saying is absolutely crystal clear, but it's also the truth. And why am I saying it? Because I have love in my heart and I do care about human rights. I care
I mean,
about them.
No, I mean, I
What are
met
you
this
gonna
guy.
do?
I met this guy at an event like 15 years ago. And we started talking, and we've been friends ever since. And I've seen Roger quietly does some amazing things, and I can't thank you enough for your courage and your outspokenness on behalf of human rights victims and what you do. But please don't go away. I
Well,
just
and
want to.
I
What's that?
thank all of you. And Marty, obviously,
Yeah.
Marty, we're brothers and
Thank
Paul.
you. Of
And now I
course.
see new brothers and sisters here tonight.
Oh yeah. Well,
So
you remember Ayisha too? Do you remember from the event at Ethical Culture Society?
how could I forget her?
And she's a first-year law student at UCLA now.
Wow.
She could probably teach. She
Congratulations.
could probably teach half the classes she's taking.
Well,
But
congratulations, Ayisha.
you're on, Ayisha, you're on mute.
Stephen, can I jump in real quick? Because
I was just gonna send it to you, big man.
I have to say,
Yeah.
listen,
Yeah.
between what we heard from Natali and what we heard from Roger, I really want to say what's most one of the biggest travesties of this case is that they are allowing the court system to turn a moment of amazing solidarity with Indigenous water protectors that moved the world, we just heard a song from Roger Waters about it, into a SLAPP suit to try to punish Greenpeace, to take the story away from the people from the water protectors who put their lives on the line, who suffered, who are defending the earth, who are still out there doing that. And instead, they want the story to be, let's make Greenpeace pay some money for some lockboxes in a trial that has been so unbelievably biased and unfair, even to a layman who's not a lawyer. It's obvious. Yet we can't let them turn the story away from what it should be. So those songs need to be written, they need to be recorded, and this story has to be told the way it should be told. And it has to continue to do so throughout the upcoming battles that we have attacking our free speech rights and the ability to organize, and especially those frontline communities, because it's Standing Rock, it's communities on the fence line of refineries and drilling in California, it's Louisiana's Cancer Alley. All of these communities will be silenced if this process is allowed to go forth without groups like us monitoring it and calling it out. So I'm so inspired by both what Natali said and, of course, the song. And I can't wait to actually hear a recorded version, Roger. I'd love to be in the studio when you do it.
Well, that was great. Thank you for saying all of that, Paul. But the other thing, of course, all those years ago as well, I was saying, actually, I'm talking about Gaza now. I'm talking about Israel-Palestine. I was saying this battle is going to be fought on the campuses of the universities of North America. But I didn't know it was going to be fought with brutal militarized police breaking the heads of wonderful young men and women simply standing up for human rights and protesting genocide. I thought it might be a battle of contrasting arguments about the rights and wrongs of some of it, but no, it's not. It's militarized police beating. If necessary, they will go on and start shooting them and beating them to death.
Well,
if Trump hasn't deported them all in the meantime.
Yeah, and I'll say, I mean, that's a good segue to just at least briefly touch on the case of Mahmoud Khalil from the Columbia grad student who was just snatched, abducted out of his
Yeah.
apartment without a warrant. And just about, I mean, he's now detained in Louisiana, and he should come home immediately. This is the most, honestly, this is one of the more frightening things of a lot of frightening things we've seen in recent weeks. I have no doubt if Trump gets away with this, he's going to try to exile U.S. citizens, people perhaps like myself or Natali or people on this call, just for speaking out in ways that he doesn't like. We are in a code red alert moment for freedom, for free speech, for the right to advocate in this country right now. And it's playing out in this even though the Greenpeace trial has gone on since 2017, the fact that Trump just came in is doing all this, and that's the environment around this trial, makes it even worse.
Yeah.
So
if I could add to that,
Yeah.
Stephen, I was on the campus at Columbia when it started, but I was faculty at NYU at the moment, and then I was at Yale, and I was there with the students when we started the encampments. So across New York City, the kind of treatment by the police and then our administrations in of itself, I mean, the fact that universities are giving information of their own students away to the feds should be blaring alarms to all of us. It's not just green card holders. It's not just people who have a complicated citizenship status. They are doxing their own students.
Yep.
And the level of fear, just now I'll speak as a young Muslim woman who experienced parts of the Muslim ban when Trump initially established it. The kind of fear that my colleagues and my community is facing has been immense. We haven't seen this kind of racial discrimination since the Japanese internment camps back in the back when we were still fighting in World War II. And so there's a massive justification of these incredibly not just racist, but like punishment theories that we're establishing. And just yesterday, I was reading that anyone who got funding from the EPA under Biden's administration is now going to be charged with potential fraud, because the funding that folks were receiving to do work for the environment is now considered illegitimate. And so the drill baby drill theory is not just about our planet. It's not just about oil. It is about ostracizing and creating a new kind of post 9/11 era, post I'm having difficulty qualifying this without getting too vulgar. We're definitely in a state where not only is there fear of just across the board, across campuses, for students to stand up, but we're in the brink of a collapsing economy. So you have these lawsuits, you have protests being threatened, you have judges being bought out by corporations, you have incredibly racist driven policies, and then our economy is collapsing. Our country, to the level of like hell that we're entering towards, just as somebody who's not even graduated law school, is profound. I can't even begin imagining the consequences of this, like a potential recession in the middle of a police state, in the middle of like people not even being able to speak up, because what Mahmoud Khalil did wasn't illegal. He was negotiating with Columbia. I was negotiating with NYU. It was conversations. None of that is illegal. And so the targeting of individuals, the targeting of entities we deem good, because Greenpeace was deemed good for so many years, and just this twisting of history. We're in a fascist regime. There's nothing else to call it.
That was awesome, Ayisha. Thank you for that. I just want to say before we go back to others, there's a woman in a red jacket in Scott's frame. I don't know if people can see her. I just want to acknowledge her. Her name is Sarah Vogel. She's an attorney in North Dakota who lives in Bismarck and has been like offering us amazing support to the trial monitoring team, and to the law students. She's also a noted author. She's a lawyer who represents small farmers. You know, you can explain this better, but I think in North Dakota, most lawyers represent big, powerful economic interests. And then there's the small group that represents the farmers and the real people. And Sarah's one of those lawyers, and she's been amazingly helpful to us. Thank you, Sarah.
Let me just say this, that book is wonderful. That book will show you, and certainly it taught me a great deal of what North Dakota is, the struggles it has, and the oppression of other groups. It's a wonderful, wonderful book, and she should get a wide audience for it.
Yeah. What, Sarah, remind me the name of your book. What's it called?
The Farmer's Lawyer.
The Farmer's Lawyer. That's a great title. Sarah, do you want to say something to this group? I mean, we thank you so much for your work over your lifetime and for helping us. What do you think of this trial? What does it mean for the state of North Dakota?
Well, I'm deeply ashamed of the state of North Dakota for having this trial. I like to think that we're better than this trial. But the fact is, this is what's happening. It is a SLAPP suit. It's brought in Mandan, North Dakota, town I lived in for a while, went to high school in, and it's not. It was horrible watching the jury selection, and it's been kind of rough watching this whole trial. I'm still hopeful. I might be the only hopeful person that the case will be dismissed when it goes to the jury. The jury will find $1 damage or something like super low. But it's kind of hard watching this trial and all its flaws. And I've represented so many Native American clients, and and I know what happened at Standing Rock. It was Indigenous led. No one that has testified, including a Unitarian who was down there all the time, heard that Greenpeace was even there. So I'm really grateful, and I've had a wonderful time visiting with all the visiting lawyers. It's been a blast. I mean, I shouldn't have so much fun in such a horrible trial, but it's been great for me.
Well, thank you, Sarah. You're awesome. Scott, I don't know if would any of the students want to just say a few words about their experience as law students sitting in that courtroom? Do you want to give the opportunity? More than welcome.
Is anybody here? You want to?
I'll just say something quickly. My name's Kier. I'm a 2L at Columbia Law, and I'd just like to echo what we've all been saying here. There's really some major concerns about bias and incompetence in this courtroom, and I think that's kind of something that all the monitors have felt. So very happy and to be part of this and be in the courtroom, but very worried about this outcome as well.
Thank you for that.
Hi, I'm Alex. I'm a 2L from Georgetown. And it's been really, I think, cool to be here, because I think a lot of times in these times when you try to just say the truth, people look at you like you're exaggerating, or that like you're almost conspiratorial for just calling out the kind of grave injustices that are happening and calling them for what they really are. And I feel like that is happening a lot in the courtroom, and it feels very very accepted and straightforward in a way that you kind of almost don't expect in law school, that you think it'll be like better hidden or more below the surface, and just to see it all be there right out in plain view and to not have it openly addressed as a problem is kind of wild to see. And then to go back to law school after this and try to learn it and think that it isn't all what this was.
Yeah.
Anybody? Go ahead.
I'm Caleb. I'm also a 2L from Georgetown. Just to echo Alex's point, definitely feels as though we're living in a post-truth society right now, not only in Trump's second term, but also when we go to the courtroom. The ways in which some of the attorneys are bending the truth and, from my perspective, flat out just saying falsities is really striking. And sometimes it gets called out, but unfortunately, I don't think it's being called out vigilantly enough. And it is definitely incredibly insightful to be having this experience compared to how we're learning in the classroom.
So, I'm
Steven,
sorry.
I want to
Oh,
say,
but please.
I want to give Sarah just one more opportunity to say something.
I discovered the night before last that the premise of my case, which was the Goldberg versus Kelly U.S. Supreme Court case, was brought by Marty. So
Yes.
this is like, when I saw that, I was just amazed at how small the world is and how important the Constitution is and how important it is that lawyers like Marty and the others on this phone call and Zoom call are doing this work. So I'm grateful for the work of the monitors and for all of these lawyers that care what is happening in North Dakota right now. So thank you. And thank you, Marty, for Goldberg
Thank you.
versus Kelly.
Yeah,
Hey.
but by the way, for those out there, Goldberg v. Kelly is one of the seminal Supreme Court cases in our country. It's a good one. Marty, I know you helped bring that to the Supreme Court. You want to just to briefly tell people what it is real quick?
It was the begin. I was then the co-director of at Columbia University, a program on war and poverty in the 1960s, and it was a way of getting into poor law. Poor law had been building up over a number of decades, but had never been fully litigated. Namely, all these different kinds of poor laws that were used against, let's say, poor people, and specifically with the case dealt with is the right of a welfare recipient to be told why they were being cut off, and to give any proof that they could. It affects every welfare recipient, every government beneficiary recipient in the United States. It affects 10 to hundreds of millions of people. So it was an extraordinary case, and it was the beginning, the seminal case in the start of poor law at the United States Supreme Court.
Thank you, Marty. That's awesome. So we're going to have to go a few more minutes, and I want to give everyone a chance to just wrap up, including especially Roger. You have another song or hidden, feel free to share it with us.
I do.
I want to go to Scott Badenoch on site in North Dakota. Scott, give us more stuff. I mean, we want to get a better feel for what happened, and also the whole Kelsey Warren deposition. For those of you who don't know, Kelsey Warren is the CEO of the company bringing this lawsuit. He's the driving force, in my opinion, behind the lawsuit. He's the emotional support of the lawsuit. He's a multi-billionaire. He's financing the lawsuit, and he's made comments that strongly suggest it's a real personal vendetta of his against all climate activists and indigenous peoples who bravely and courageously stood in the way of this very destructive pipeline. So this guy is he doesn't have the courage to actually show up physically in court, but apparently he was deposed, and they showed his deposition or played his deposition testimony today. And Scott, I wanted to turn it over to you to
I can
help us
see
understand what happened.
I can see why he didn't want to show up live in court after seeing the depot. In the depot, he literally admitted to going to David Archambault, flying in a blizzard to go to David Archambault's home, the former leader of the tribe, to offer cash, a luxury ranch, and a school for the local community as a exchange for allowing them to move the pipeline through the disputed land. He admitted that outright. And
Wow.
then he said that the only reason why David Archambault did not take that bribe was because Earth Justice, their lawyers, must have given them a much, much, much bigger bribe. And who knows what else they gave. Wink, wink. And he repeated that multiple times. It is his contention that Earth Justice is behind the whole paying of protesters and everything else. Mind you, that's pretty interesting, given that it's Greenpeace on trial and not Earth Justice. I wonder how that is. So he literally told on himself in the depot that he's more than happy to engage in bribery to get what he wants. And that if the person doesn't take the bribe, it must be that someone else gave a bigger bribe, right? But when asked who Earth Justice was, he immediately said, oh, yeah, I know who they are. They're scumbags. No equivocation whatsoever. The clarity with which he hates climate activism is very, very obvious. We watched a half hour of the man, and that's all you'd need to see. So you can see how this case is being driven from that deposition.
He once did an interview saying he thought all activists should be removed from the gene pool. He's a very hateful person, and worse. But I'll just leave it at that. He's very hateful. Go ahead, Scott.
There, usually in trial monitoring, there are a number of things that happen, and you sort of analyze them, and you can draw a pattern. You can create a sense of where there's been violations, but you usually have to work quite hard, and you need to do a lot of research. And the fruit is usually not low-hanging fruit. You have to develop it, and you have to be very aware, and it takes a tremendous amount of effort. This case is not like that. I wouldn't even call it low-hanging fruit. I would call it a bounty of fruit that's already on the floor, and you can just pick it up. There's that many violations on a session-by-session basis of fundamental fair trial, fundamental public trial, and 3 big buckets. Figured I'd share these with you. The first is inequality of arms, meaning instances when the other side is held down, essentially their arm is tied behind their back with something that happens in the courtroom. And today we saw 2 critical pieces of defense from Greenpeace not allowed. And in situations that, frankly, had no logical explanation for them. The first was a pipeline safety expert that they had brought forward to describe how often this pipeline leaks. And apparently it's hundreds and hundreds and hundreds of times.
All right.
But they were not allowed to bring that in because Gibson Dunn claimed that they had taken all of the expertise out, all of their expert comments about the pipeline out of the complaint. So it was irrelevant. Yet, those of us who've attended this trial, including Paul for multiple days, Stephen, we saw multiple energy transfer experts and witnesses deliver all kinds of puffery about how incredible their safety record is and how unassailable they are as a pipeline company over and over and over again. Yet, Greenpeace is not allowed to provide their own pipeline safety expert to refute that. Second is Gibson Dunn based one of their major aspects of the complaint on an ESG report that was used by banks to decide to disinvest or to divest from the energy transfer loan and then later the bond. That report that Gibson Dunn used in its own complaint goes on to say, when you read the actual report, that there were lots of reasons why the investment was not good. Greenpeace was not even on the list. When Greenpeace attorneys attempt to enter this report, this seminal report, into evidence, it was denied. They were not allowed to put the actual report into evidence or talk about it.
Can I respond? Can I respond to that real quick?
Please, Steve.
That's so incredible. We'll go about another few minutes because we've already been on an hour and a half. But I mean, people. I mean, I'm enjoying myself. Maybe we can keep talking. But I just want to say this: what you just described is how trials get rigged, or one-way trials get rigged. You know, first of all, I believe this trial was rigged from the get-go just because of where it was located, with the jury that's 97% unable to sit in a fair way. So having the trial in that county, a fair trial in that county, is impossible. Then once you get into court, since I believe energy transfer case is really so weak, they're using scare tactics, and then they still need additional help from the judge in keeping out critical evidence that Greenpeace needs to defend itself. Those two documents are central to the defense of Greenpeace. And in a trial, a judge has just completely knocked them out. It's another way of saying they cannot defend themselves.
Agreed. And that's the international term is inequality of arms. It's not a term that the U.S.
Oh,
knows.
you had another point. Yeah, go ahead. I'm sorry.
Okay. But the second bucket that we've been seeing, that we saw again in spades today, as we do in every single session, and we have not missed a wink of this trial, is what we would call the competency of the magistrate. Is the judge capable and competent to rule over the complexities in front of him? And it is very patently obvious that this judge does not have that capacity. Not only do we see that by his rulings and his lack of understanding of the basic rules of evidence, for instance, but by all of the different actions that the judge has taken, where he says that he is going to grant a certain motion and then for no reason opposes it later and admits he can't even remember what he ruled the first time, and he will ask counsel to remind him. So the level of confusion that he displays on a session by session basis has made it very clear that he is out of his depth to rule on what is one of the most complex nonprofit lawsuits we've ever seen, and one of the most complex SLAPP suits you'll face. Somebody who's never faced any cases like this whatsoever. He was a former fence line dispute guy. So we have seen him tell on himself on a session by session basis that he is way in over his head. And that goes to the competency of the magistrate and therefore the fairness of the trial itself. And the third and last bucket that, again, we are fine. The buckets are full. They're falling over. At each session, we are filling them back up and trying to get a bigger bucket. The third bucket is what I call, for short, bad faith of counsel. And I think my colleague here mentioned earlier the incredibly frequent, what we believe we've seen as abuse of the judicial system. In fact, the bullying of this judge himself by the counsel for energy transfer, the repeated disrespect and abuse and bully tactics that we've seen amount to bad faith tactics. But then there's more, because just today, Trey Cox, their lead attorney, asked the judge if they were okay with having a off-the-record meeting at a hotel conference room to sort out some of their remaining questions. Why would you ask for an off-the-record weekend meeting in a hotel conference room when you have 2 more weeks of scheduled trial that they demanded? They have 5 weeks, by the way. So these 3 buckets, bad faith of counsel, competency of magistrate, and inequality of arms, we are seeing with such repetition that it's hard to describe. So those are our 3 buckets. We saw them today, just like we have every single session. But I'll leave it to that. I see some questions coming on the side. I can't read fast enough.
Thank you. That was awesome. We're gonna right now. It's 8:33. Well, let's shoot for 8:45 to end this. If people have questions, throw them in the chat. I see that Jeanne Mirer is back. Jeanne, I wanted to give you a chance to comment again on what you've heard or any thoughts you might have.
Well, I'm sorry I had to leave before I had an important call. I think I told Natali that I might have to go and come back. But no, this is I've listened to everybody and I don't really have anything to add. I think clearly the question of the competency of the magistrate, the question, some of the things that have been said, the fact that the magistrate is so I believe, demonstrating his incompetence is confusing the hell out of the jury. And, you know, if you're trying to tell a story about what the evidence that was presented to them showed, and there's the plaintiff's counsel has been able to make editorial comments on all kinds of things as the evidence comes in, and the judge has let him and do that, and you know, the jury confusion is going to be so profound that that even if there was, you know, a group that in the jury that maybe don't want to find Greenpeace liable, it's going to be hard for them to articulate reasons from based on the evidence. That's what my concern is based on all of this stuff that I've been hearing.
Natali, any closing thoughts
Yeah,
from
thank
your perspective?
So just to say, we shared a link there in the chat. The link is to a public summary of the Foley-Hoag report that Scott was mentioning was not allowed in court as evidence today. But there is a public summary version that is public, that you can read, that you can absolutely sift through. But what it says is exactly that, right? That there was no tribal consultation, that tribal consultation was inadequate, that Energy Transfer and Dakota Access Pipeline failed to actually meet any of the baseline standards of consultation, of free, prior, and informed consent, or any of the banking standards that are relevant and necessary in this case, right? And this is an independent assessment for the banks that was ordered, and this was not allowed in the trial as evidence, right? The other thing that was not allowed in evidence at the trial, which Scott was bringing up, was an exponent report, right? An expert report. And if you look at Mike Sorgan, he's got some great articles on this, but talks about the 1.4 million gallons of potentially toxic drilling fluid that have reached Lake Oahe already, reached it in 2017 during the construction of this pipeline, in 700 unreported frack out events. So I cannot stress this enough, right? One of the things that we have to take into consideration and understand is that as this, you know, sham trial is happening in a small courthouse in Mandan, North Dakota, which is the same courthouse where water protectors, over 800 cases of water protectors at Standing Rock were brought in to have to defend their ability to stand, right, to protect the water. This pipeline is still operating illegally. It is operating without proper permitting. It is operating by a pipeline company that has been federally debarred, which means they cannot enter into contracts with the federal government because they have a poor safety record and contaminated the water in 2017 in Pennsylvania and Ohio. So if we go on and on, I mean, the amount of issues that we're seeing here, I mean, it's not just a travesty of justice, right, happening in Mandan, North Dakota in this case. Like, this, again, is still about this pipeline that is operating illegally without proper permitting, without the consent of the Standing Rock Sioux tribe. And there's ongoing litigation by the tribe happening right now in the DC circuit to put an end, to stop the contamination, to bring attention to the desecration of the sacred sites and cultural sites that happened at Standing Rock. And that's what I think we also have to remember and center. So when people are asking, right, because people will ask, what's the call to action here? How do we help? How do we get involved? What can we do? Because I think we're all over just taking this, right? Part one is really having an understanding that it's about education, education of ourselves, education of our relatives, education of everybody that, you know, is not paying attention to this. I can name plenty of lawyers that don't know that this is even happening right now.
Yeah.
Right. And it's a very specialized, you know, audience. But so if you're listening to this and you're watching this live stream today, you know, share it with other people. Support the work of the Standing Rock Sioux tribe. You know, they are continuously fighting, still fighting to protect the water nearly 10 years later. and share out this information as best you can, right? We have to educate ourselves. We have to, and Roger, you know, I loved your song. You know, I wish it was just the Trump administration, but we also forget in the United States, like there's this tendency to forget that as Indigenous peoples, we've had to stand, right, for centuries and through all kinds of administrations. It was Obama that allowed this to go through. Biden didn't stop it, right? So we
Right.
have to like recognize that this is part of a systemic attack on the right to protect the water. And just yesterday, we're seeing the largest. It was announced as the largest state of deregulation for the EPA, and a massive shift in the Environmental Protection Agency as no longer an EPA, but seeing how can we facilitate corporations and businesses, right, to have access to public lands and have access to using the water, putting an end to water and air pollution standards that have been in place since the 1970s. Since the 1970s, and I'm sorry I'm on a soapbox here, Stephen, but the 1970s, if we go back to the origin of environmental law in this country, it started as a bipartisan effort. This was people across the country, right? Like across the political aisle coming together and saying, you know what? It's time for our country to wake up and understand that this is not a political issue. This is not a partisan issue. This is about a basic understanding of what is life and what we have to do to protect it. And we have to carry that responsibility as a sacred responsibility, whether we believe in things that are sacred or not. But how you get more sacred than life, I really don't know. But that's where we're at, right? And this is the critical juncture that we've once again reached.
Roger, hold on one second.
That's a wonderful statement.
I just want to say thank you for that. I also want to say that Natali, I consider Natali to be one of the great leaders of this country and this world.
Yeah.
And she runs an organization that she's not going to say this, but I'm going to say it, that also needs support. It's called the Water Protector Legal Collective. And not enough people know about their work on behalf of Indigenous peoples all over this country and world. And on behalf of me, obviously a non-Indigenous person who spent a good many years trying to assist Indigenous communities in the Amazon fight Chevron, you know, and Natali's a great person and a great lawyer and a brilliant leader. Water Protector Legal Collective, and maybe Xander, I don't know if there's a way to put a link to her organization in the chat such that people can go directly to it. But if you can't, when we're done, go to Water Protector Legal Collective and find out about their work and try to support them. I'm going to go to Paul, and then we're going to close with Roger, if you can just hold on one second. Paul, do you have anything you want to say? Oh, and Marty, too. Paul, do you have anything you want to say briefly?
Yeah, really briefly, and thank you, and I'm sorry that I was late, but we're having a meeting the last 2 days with a coalition of groups that are working to protect the rights of people to speak out, to dissent, to protest. And a lot of what we've seen in the courtroom is the attempt from corporations, and specifically ETP, but Gibson Dunn, to not only criminalize our work, our voices, and in this cases, criminalize the lives of Indigenous peoples, but the right to actually speak out and dissent. Destruction of property, I'm sorry, is not violence. Blockading a road is not violence. We heard the sheriff of Morton County say that when they blocked the roads during Thanksgiving Day protests, that was a violent act because people were prevented from going down a road. That is the slope that they want to push water protectors, Indigenous rights activists, environmental justice activists. The attempt is to criminalize. And now we're seeing Donald Trump say that protesting Tesla and Elon Musk is a crime. We are very much on the brink of having the existence of all the people here and the organizations, the work we do, criminalized and attacked and investigated by essentially, as someone has said, a fascist regime. There's no more important time to pay attention to what's going on and get involved. So please find out, because it is very close to being your door. Whatever you think you are, if you're here, you're listening to this, you already care. They know you care. Stand up with the people that are fighting and make sure they don't criminalize our work, and keep monitoring what's going on, because it's vitally important today. Every day it gets a little bit worse. So I'm really appreciative of having this call and having me be on it, and that Amazon Watch could be a part of the monitoring committee.
Thank you, Paul. And for those who want to learn more about Amazon Watch, go to amazonwatch.org. They've stood by the people of Ecuador that I've represented for 25 years. They're probably one of the best frontline groups, really working at the grassroots level to help indigenous peoples in the Amazon. Thank you for being here, for your work. Great respect for you. Marty?
I think this has been a wonderful, wonderful discussion. I'm sure that you will try to get it so that a maximum number of people see it. I think that so many different areas which are related but sometimes separable, Indigenous rights, First Amendment, Constitution, were woven together by all of those who spoke, Jeanne. I think it's been a wonderful session. I hope it gets circulated.
Thank you for being here. We love you, man. Thank you so much for what you've done your whole life and continue to do. Continue to do.
Right.
And by the way, Marty is going back with me and some family members to North Dakota for the end of this trial. So those in North Dakota, you'll be seeing him again.
See you soon, Marty.
Thank you.
Roger.
Yeah.
I want to hear your thoughts about all this. So I just want to point out to our audience that, okay, a lot of people know Roger because of his forward-facing musical work over his lifetime, which is, I can't even begin to describe the body of beauty you have contributed to humanity. Thank you for doing that and continuing to do that. You're amazing. Okay. We love you and we benefit from you every single day. A lot of people don't know that you have been really viciously attacked because of your human rights work. People have tried to silence you.
Yes,
just like they're trying to silence Greenpeace. So when you look at this whole thing, and me, and Natali, and the Standing Rock Sioux, and and the people of Ecuador. So when you look at this, like, what do you see?
So you were cut off for that last section.
I'm saying when you just what are your thoughts on this whole thing? What are you seeing?
Listen, my thoughts on this whole thing. I want to thank Natali because she, in that recent, very moving speech that she made just then, she's encouraged me to give you a little bit more, a tiny couple of bars of a different song, and only because it relates to this subject and to the water protectors specifically. And if I get a bit emotional, you'll have to forgive me, because I do get a bit emotional. And if I use the F word a few times during the repeating of these lyrics, you forgive me for that. And if it offends you, put your fingers in your effing ears, all right? Please. Okay. This is just a couple of verses from a song called The Bar that I've been singing odd verses of it all over the tours I've been doing recently. So it's and there are two women in this bit. One is a homeless black woman from New York, and the other is an Indigenous and Native American woman from North Dakota who has helped her and has brought us to a bar where we all are. And this is just a couple of little bits. And thank you so much for having me on. And I've been fascinated listening to everybody's information about the buckets of shit in the bar. Well, fruit. Sorry, it was fruit, as I recall. But you know what I mean. It was very informative. So here we go. These are just a couple of things. Does everybody in the bar feel shame? Lord knows I do. I guess we all feel pretty much the same, kind of wore out by this crazy fucking zoo. The smell of napalm with the cornflakes, the chafe of killing everything that breathes, imposing sanctions on the lady down the street till she takes the hint and packs her bags and leaves. But come on in here, sister, and set a spell. You are most welcome in the bar. We may seem few, but we are many. Have you been traveling far? The girl who brought you in here is Lakota from Standing Rock, where they made their stand. So from Fort Yates, North Dakota, Here's a message for the man. Would you kindly get the fuck off our land? And then the black lady sings. So I have to explain that. Hey, barman, I have a question. As one of many victims, tell me why a failed fat fucking landlord has been chosen to decide who should live and who should die. And the barman says, sweetheart, there's a reason you come in here. And she says, I know, I was just putting on my dancing shoes. And together they sing, with the right set of moves, we can turn this ship around. Together, we can write tomorrow's news. So that's just a moment of hope, you know, for the future,
great.
because we can write tomorrow's news. Together, we can write tomorrow's news, and it will be good news for all of us. And thank you all for having me here tonight. It's been
Roger, that was great. Great.
all right.
Beautiful.
Thank you.
And don't hang on one second. We're gonna, unless anyone has anything super urgent, we've been on almost 2 hours actually. It's been amazing. We're gonna wrap up now. I wanna, before we do that, first of all, thanks to everyone for doing this. This has been, I've been really moved myself, and everyone is so beautiful. And the fact is, you know, what's interesting is when you have these travesties, solidarity rises up. We're seeing it with Mahmoud Khalil. We're seeing it with Greenpeace. I saw it in my own case, basically saved the life of me and my family due to many of you on this call and many thousands out there. So, you know, they want us to believe we don't have the power. Okay. We do have the power. That's why they do these things. But they're trying to psychologically convince us we can't fix this. We can fix it if we organize and recognize what it is and come up with a plan and start moving on it. And, you know, this is a long road. We can do this. And I just want to urge people to stay engaged. Our site as Trial Monitors is called trialmonitors.org. We plan to not only produce this report, we plan to continue operating until the end of this case, which will probably be at least 1 to 2 years from now. We're going to make our voices as independent monitors as loud as we possibly can, based on all the evidence we're gathering, some of which you heard from Scott and others today about the major flaws in this trial. So we are going to keep going. By the way, get familiar with our website. We're going to keep posting information, and you know, we're going to keep moving. And I especially want to thank the law students for leaving law school, okay, and going all the way to North Dakota to help this effort. Last week there were law students from Georgetown who drove in 2 cars, 6 students, all the way from Washington, D.C. to the courthouse in North Dakota so they could spend the week there. Okay. We could not do this without that support. Thank you. Your work is so important to us. And thank you, Scott Badenoch, for organizing the students and organizing this whole thing. And Roger, thank you for coming, man. I mean, you added a real special dimension to this talk tonight. We love you. Thank you so much. With that, I think we can go. If we get more questions in the chat that we haven't answered, we'll try to answer them on the website, just to be clear, okay? And thanks to everybody for participating. And continue, by the way, Greenpeace is isolated on purpose. Support Greenpeace. Help protect Greenpeace in this critical moment. They have a website called greenpeaceontrial.org where you can learn more about their point of view on all this and help give them support. So help protect Greenpeace, help protect the right to protest, help protect all entities and people hit with SLAPP suits. Stay engaged and keep watching this, and we'll be monitoring it and giving you more information as we go forward. Thank you. There's a lot. Thank you very much.
Bye-bye.
Bye. Thanks, Steve.
Thank you.